I'm really grateful to PLEA for giving me this wonderful opportunity, for giving Malcolm and Malcolm this wonderful opportunity time and again. One thing I realized when I was preparing for the webinar is very few books are written on purely on the matter of private trust. And I understand the how difficult it would be for students to appreciate the concept of a private trust, the concept of a family trust, because if you open firstly the word itself, the word trust is rather misleading. The minute you mention the word trust, people think of a public trust. They don't think of a private trust. They don't think that it is possible to constitute a private trust with certain charitable objects. Your objects may also be religious. You may be the owner of a property. You may be in your 60s, 70s, 80s, and you may feel like leaving the property for your own posterity, for your own children, for your own lineal descendants. And the minute you think of a trust or a trust-like structure, you think of a public trust. Well, that is not the case. And I don't, I don't blame the students for the confusion, because the minute, if you look at the Indian Trust Act, now Indian Trust Act is the act which governs the, is the act which talks about private trust, how they should be managed, how you should appoint trustees, how to form a trust, which is the relevant code, etc., etc. So the minute you, so I would, on this particular point, what is a trust? I would like to give what is a family trust? I would like to share a very interesting anecdote. In my junior days, one of my colleagues, she got a dressing down. She got a dressing down from a reporting partner. Where the reporting partners back there used to give a dressing down for just about everything. Anyways, so she came to me in a flat. She was handling a litigation matter in which the parties had decided to settle the issue. She therefore drafted something called the deed of settlement. Now, when she drafted this particular deed of settlement, she advised the client about the applicable stamp duty. And at the time the partner was settling this deed of settlement, finalizing this deed of settlement, he came across an entry in the Maharashtra Stamp Act, a specific entry with respect to stamping of settlements. So that's where, and that's how the, what should I say, cookie crumbled when she came to me. And at that time, I remember, I didn't even, when she told me about this litigation and this deed of settlement that she had drafted, I didn't even bother opening the Stamp Act. All I told her was, it is highly unlikely that a settlement between two warring factions of a commercial nature will fall within the four corners of the definition of settlement given in the Maharashtra Stamp Act. And today, really, if I were to explain what a family trust is, I would rather refer to the definition given in the Maharashtra Stamp Act of Settlement than the definition of private trust given in the Indian Trust Act. So essentially, the heart and the nub of the issue is that there is a property, you are the owner of the property, and you would like to transfer this property for the benefit for your own benefit during your lifetime, or for the benefit of your own benefit and that of your children, for a group of persons. And so it's something annexed to the ownership of the property. You are creating by creating a deed of settlement or by creating a trust, you are creating an entire code for the management of a property, for the disposal of the property. So as I mentioned earlier, what is a trust? Is an application annexed to this. This is the first part is the definition given by the Trust Act. But let's look at the definition given by the Maharashtra Stamp Act, the definition of settlement. Non-testamentary disposition of movable or immovable property made in consideration of marriage for the purpose of distribution of property amongst family members for religious or charitable purposes. So there are a couple of things I would like everybody to be very careful about while drafting a trust deed or a deed of settlement. There are a lot of precedents. Precedents are dime a dozen, And that's where the problem starts. The copy paste function of Microsoft Word has created a lot of issues, which is very good for litigation lawyers, but it reflects very badly on transactional or drafting lawyers. So and it is often said that the deed of settlement must be in the nature of a deed poll. What a deed poll is that, and it can be a unilateral declaration, it can be a unilateral document. Of course, I'm not in the favor of a deed of trust or a private trust deed being a deed poll for reasons I'll explain later. But when you decide to form a private trust, your foremost objective, see, if you and I were to draft a commercial contract, we would understand the nature of the client's business. Similarly, when we sit down to draft a private trustee, we need to understand the intention of the settler. And one of the things you have to really be careful about is make sure that the beneficiaries are clearly identified, that the beneficiaries is a class. If the beneficiaries cannot be clearly identified, or the beneficiaries are not a definite number of people, then you run the risk of converting a private family trust into a public trust. And people always, you'll come across a lot of governance, and even in public trustee, where they say that, okay, I'm settling this property in trust. So I have a bungalow, which I decide to, donate for charitable purposes. I'm very fond of having a library. I can, in my times, at Churchgate, there were a lot of these second-hand booksellers. And as soon as every time I would get time, I would go to the second-hand bookstores and just pick up books. Now, if I decide to have a library, and for the benefit of the whole work, for the benefit of public, it becomes a public trust. So even if I in my trust deed write that only my children can be the trustees, or my lineal descendants can be the trustees, it doesn't mean much, because the entire property has to be used as a library for the benefit of public at large. And I have invited one of my close friends, clients. He's the real estate head at JSW Steel, Mr. Deepak Joshi, to tell us how painful a public trust can be. Mr. Joshi, are you there?
Hello, hi Divya, hello everyone.
Well, I'm so glad that you, in spite of your busy schedule as the legal head of JSW Steel, you decided to accept our invitation. And I'm on the point of being very being very specific about a dedication made in the deed of settlement. So supposing I, as the settler, decide to settle a property in trust, and I just forget to write in the trust deed that my library shall be only for the benefit of my lineal descendants. And I say I have decided to settle this particular property for the purpose of library, and don't specify any class of people. And can it be construed as public trust? And what are the difficulties in public trust? How draconian Maharashtra Public Trust Act can be, and how the charity commissioner functions. What has your experience been with public trust?
So basically, public trust is under the Bombay Public Charitable Trust Act, and there are so many restrictions on the public trust, especially since we deal with the properties. So especially for disposal of the properties. So trustees cannot dispose of the property without permission of the charity commissioner under this 36 of the Bombay Charitable Public Trust Act. If I want to dispose of the property, I need to first take a permission of the charity commissioner. But obtaining a permission from the charity commissioner is very difficult, since there are so many restrictions. So it's like a public auction. So there are the charity commissioner is the regulator. So there are so many things which you need to follow as a for day-to-day functioning of the trust and for the disposal of the properties as well.
That's exactly the point. I was thinking about that. Once the public trust is not that only for no. Even if the trust deed says that the trustees have the right to dispose of the property, it doesn't mean much. I think you would still have to go to the charity commissioner, isn't it? Not matter.
Yes.
It hardly matters what the trust deed says.
Right. So whatever written in the trust is because a charitable trust has so many benefit in the terms of taxation and a few other things. So therefore, this charity commissioner is the regulator, since you are taking many benefits under the charitable trust act. So you need to go to charity commissioner, approach him, and it should also there in the trust deed that trustees are entitled to dispose of the property, or the property can be disposed of, but it should be disposed of only for the benefit of the trust. So whatever the receivables or whatever consideration you will get out of disposal of the property, you need to invest in the benefit of the trust only. So
That is as far as disposal is concerned. But even if
yes,
you don't intend to dispose the property, the governing body is subject to the jurisdiction of charity commissioner. And
right.
I believe any two beneficiaries can get up and make things miserable for the governing for the management.
Yes, yes. So you will find there are so many litigations pending before the charity commissioner where there is a dispute between the trustees and allegation, counter allegation. Sometime administrator has been appointed. It's very difficult to work,
Manage public
manage
trust.
on day-to-day basis various things, because the bank account, the properties, the act of the trust, everything is regulated by the charity commissioner, and there are so many disputes. You will find so many disputes.
So,
So lot of
that,
litigation is pending.
that's exactly why when you decide to draft a deed of settlement, identify your class of people, your lineal descendants, whosoever you intend to, family members, specify the family member, be very specific as to what kind of, about the beneficiaries, because everything will turn around, the entire document will be interpreted based on the objects and the benefits of the deed of settlement. Now, as far as movable property is concerned, we just went through the definition of settlement given under the Maharashtra Stamp Act. As far as movable properties are concerned, there's not much of an issue. You can just make a deed of declaration and the property can be settled. But where immovable property is concerned, there are very substantial stamp duty implications. See, look at a private trustee or deed of settlement as something like a will. But unlike a will speaks from the deathbed of the testator. However, a deed of settlement is a transfer to your to the beneficiaries during your lifetime. And I think for my generation, the entire structure of private trust came into limelight because Rupert Murdoch was married to a model, and she tried to attach his properties in the divorce settlement. But then later it was realized that all his wealth was caught up in this complex web of private trust. Some people, what they do, so if there is an immovable property involved, then the private trustee has to be properly stamped, and unless the removal property is for some religious or charitable purposes of the family, the stamp duty implications are the same as that on a conveyance. So your deed of settlement, where immovable property is concerned, is stamped like a conveyance and naturally it has to be registered. So one of the other thing that I wanted to make very clear is that sometimes people feel like saying that, okay, we have a family deity, and so during the Navratri or during some special pujas or religious ceremonies must be performed on this particular property. And this is a case coming from a lot of properties in South Bombay. Over a period of time, what the families used to do, they used to invite everybody in the neighborhood for the Aarti Puja. Eventually, they ran a risk of others claiming a right of worship. So, I I often say that any system, when you sit down to, you have to lay down a complete organizational chart and code of conduct for the property that you are, which you decide to transfer to a private trust or in your deed of settlement, because so long as you are the trustee and the settler, and so long as you are alive, you'll have control over things. But you are creating a code for a code of management for your afterlife, and therefore you have to be very careful. So make sure that if you have made a wish, or if there is anything to the extent of having some pujas or religious ceremonies, it is again limited to the family and family members. Now, the other interesting thing that I wanted to mention is, why is it that I don't, people say that a trust is, a trust can be formed by it's a deed poll. So a trust can be formed by just having a declaration and end it there. One of the reasons I don't, when I sit down to draft a deed of settlement, it is important to make the settler will, the author of the trust or a settler will definitely be a party to the document, but make the at least the initial, the first set of trustees also a party to the trust deed. And the reason why I insist on doing that is, see, the office of a trusteeship has to be accepted by the trustees. So, and they have to indicate their acceptance. So might as well have everything, tied up in the deed of settlement itself. There are many instances where people have appointed professionals and third parties and executors. At the end of the day, everybody recuses himself from executing the will, and the beneficiaries are left on a limb. And for the same reason, you should, when you decide to draft a deed of settlement, make sure that the acceptance of the trustees to act as trustees too is indicated clearly in the document, that they are made parties to they too are made parties to the deed of settlement. It was when I was a student and I read that technically the property vests in the trustees. I really didn't understand what it meant, besides the fact, besides the obvious meaning. But later on, I started realizing the importance of the property vesting in the trustees, and it really came from my experience in real estate. Supreme Court judgment. See, we all know that non-agriculturists cannot acquire agricultural land or agricultural property. So a claim came up before the Supreme Court, where the trustees were, the property was given in a trust. So the Supreme Court said that, and the reason why a company or a corporate cannot be an agriculturist, because the definition of an agriculturist given in the applicable laws is that to be an agriculturist, you should personally cultivate the land. Now, you cannot cultivate a land personally unless you're a natural person, unless you're a human being. You can employ servants. However, you have to be a natural person to be able to personally cultivate a land. A company, even if it employs servants, cannot fit the definition of a party cultivating the land personally. In this particular case, it was a trust property. And what the Supreme Court held is, because the property of a trust vests in the trustees, the trust can own this particular piece of agricultural land. And that's when I realized the importance of this particular rule, which says that the trustees, although they may hold the property for third parties, for certain beneficial owners, but legally the property vests in them. And this is just a practical instance that I came across in real estate, doing title due diligence. I don't know, for God only knows how many years, day in, day out. Not the role of trustees, and I've always felt that the efficacy of a private trust depends on the integrity of the trustees. Not only are they the legal owners of the property, but they are also the entire management of the property vests in them. Now, remember, there are two important concepts over here: ownership and management, and you have to, in your trust deed, secure both. Most importantly, you have to, when one of the reasons I've asked Bapu to join us is because he has handled a very interesting case where a man created a trust in his will. So when you do a deed of declaration, you settle immovable property and get it registered. You create a private trust intervals during your lifetime, but you can also create a trust under your will. And he forgot to mention the executor. So that is, and how much time they had to spend before the court and what happened. Because we have a practical experience on hand, I thought, I thought it would be nice if he could share the experience of the firm with everybody. So now, what happens is, when you sit down, if you tie your hands, if you tie the hands of the trustees too much, especially where immovable property is concerned, then the property itself runs the risk of deterioration, and it usually happens in old immovable buildings and structures. Structures, as they age, they require a lot of care. If firstly, under law, trustees cannot mortgage the property, they cannot transfer the property, they cannot lease the property, they can't do any of that stuff. So as properties age, they require a lot of care. And under law, a trustee cannot transfer properties. He can't even, by transfer. Transfer does not mean sale alone. Transfer also means long lease. Transfer or mortgage too is a type of transfer. Now, unless, of course, now here is one of the fundamental differences between a public trust and a private trust. Besides the fact that a private trust is limited to family members, is that you can give a lot of leeway to the trustees. So, one of the beautiful trustees, I came across a beautiful trustee, beautiful building, amazing building. And of course, this was the third generation looking after the structure. In the trustee, it was specifically written that the trustees can sell the property, and they can use the sale proceeds for purchasing another property from the family if the building, if it becomes, sort of unfeasible to maintain the building. So I would, when we enter into discussions with the client, you ask, you get a sense of what they really want to do, because you will be creating something which is not about the now and immediate, which is about the future. And often trusts are created by by parents with children of special need. See, you may have a child he has certain special needs, and you may expect the other child who is better, who is perfect, to take care of a differently enabled child. But how do you ensure that this happens? You can't force the better, the healthier child to look after the younger one or the other one. So in this case, many parents therefore form a private trust where they themselves become the trustees. So that is how you can. So one of the major reasons why people form, because I don't know what are the taxation benefits, but the stamp duty implications, as I shared with you earlier, of formation of a deed of declaration are substantial. I came across, so generally what we tell our clients to do is to first form a private trust, and then especially, see, if you already have a property which you want for the benefit of your children, then that's very simple. If you're, then you just transfer, you transfer the property into the trust. You'll have to pay, say, 5%, 6%, whatever the stamp duty is. Unfortunately, I came across an instance where one person had identified a certain property. Now, this is property in South Bombay. I'm talking, this transaction was done around 1940s. He bought the property, so he paid stamp duty while buying the property in his name. And then he actually wanted the property for his family, for his lineal descendants. Then what did he do? He formed a private trust and he transferred this particular plot to the private trust. So he paid the entire stamp duty once again. What we would have done is first form the private trust and purchase the property directly in the name of the private trust. So stamp duty as a conveyance would have been payable just once. So I often tell, especially as far as students are concerned, that, or even when we deal with freshers, that what don't surprise the client by telling them what the stamp duty is at the end of the transaction, because stamp duty implications. So when you structure the, and stamp duty is something you should study when you get the mandate. As soon as you get the mandate, look up the stamp duty implications so that you can structure your entire transaction accordingly. So this is as far as structuring of a private trust where an immovable property is concerned. Now talking about management, as I said, a public trust is not that a trustee of a private trust can do whatever he likes. He is of course bound by the trust deed. So you will have to put an entire code for his conduct. In what circumstances can he sell the property? If he sells the property, how to sell the property, how to apply the proceeds of the sales, all that your trustee must mention all that. And as I said, if you don't give any leeway to your trustees, to the management, then the trust itself might fail. See, my last slide talks about, ultimately the efficacy of your trust, your family trust depends on the integrity of the trustees, depends entirely upon the trustees. And also, the couple of things we need to know as far as the trustees are concerned. Of course, as I said, one of the reasons you make all the trustees party to the document is because trust is something, an office of the trust cannot be foisted on somebody. They have to accept it, like any other office. Secondly, you can't, people apply corporate principles to the management of a trust. So you can't just recuse yourself once you have accepted the office of trusteeship. You have to go to the court. So although you don't have a charity commissioner, you don't have any governing body or any regulator checking your acts and what you do, but you are answerable to the civil court. So, for example, if the document is silent about sale of the property, then the trustee has to get an order from the civil court. And often when we deal in family properties which have been vested in trust, we do ask the client to get an order of the court. It is as good as dealing with the property of a minor to get an order of the court for sale of the property. So, as I said, give your trustees ample room, but also have a system of checks and balances. And remember, sometimes people put two or three trustees, hoping that each one will serve as a check and balance on the other, which is true. But what we also need to remember, the entire board, it stands together and collapses together. So one, trustees, it doesn't work on principle of majority. It works on principle of unanimity. That is another thing which, especially when corporate lawyers deal with trust properties, they kind of slip up on. Now discretion. So now as far as discretion is concerned, both in will and trust, be very careful when you give discretion to anybody or discretion of any sort. And people, by giving very wide descriptions, make the document ambiguous. So you can't have a trust deed where you tell the trustees that they can apply the proceeds, the funds of the trust in such manner as they like. Your trust itself that settlement will fail on the grounds of ambiguity. Similarly, you can't, this is one example where the trust fails because I came across a will, very badly drafted will, and I feel terrible because the testator had gone to the one of the best, old time law firms of his times, where they obviously, when you are 70, 80, you can't make up how much to give what, and especially if, all grandchildren are not on the same plane. So what we tested, this was a lady testatrix, yeah. What she had written my funds can be distributed as per the discretion of my um, of this particular uh, partner who had drafted the law firm. That itself can render the entire will void. And remember, whatever principles are true for drafting of a will, they also hold good for drafting of a private trust. So that is as far as a private, matters of discretion are concerned. Of course, as I said, a trusteeship is rather a privilege. It's a onus and a responsibility than a privilege and honor, quite frankly. So a trustee, if he spends his own money for preserving the property, he has a charge on the property. He has a lien on the property. But it's not something, he cannot take away the possession from the beneficiaries. How can his charge and lien be exercised? His charge and lien can be exercised in a very limited manner. If the property is sold, then he has the right to recuperate the money that he has spent on the property. Now, I have also come across instances, especially where movable or money is involved, shares are involved in a trust. The trustees mingle their own funds with that of the trust funds. So it's very difficult to find out which trusts belong to, which funds belong to whom. And as I said, we have all these scams because there's no end to human breed. But the important thing is, firstly, that in such a case, it is not that the beneficiaries, the charge. So in such a case, the beneficiaries have a charge on the funds, and it's not that their charge extends only to that portion of their funds which has been lended by the trustees with their own funds. They have a charge on the entire body of funds. So, and then of course, under law, if a trustee is mischievous fellow, then you can, firstly, if you go back to your Limitation Act, there is absolutely no bar of limitation for chasing trust property into the hands of whomsoever it may land. And you will notice that often, and I had this nasty experience in a title due diligence. The property changed hands from partnership to partnership. By the time it was to be sold to our client, we put a public notice. We got an objection from the heirs of one of the partners who was a partner some 3 partnerships back. And the heirs, the first thing that the heirs said is the remaining partners were holding the property in trust. And therefore, in spite of the lapse of time, we can chase this property and your client is put to notice. So, and in matters of, as far as, sale and purchase transactions are concerned, although there is no mandatory provisions for issuing a public notice, I make it a point to issue public notice in the newspapers. So there is this is one exception, that as far as trust properties are concerned, the beneficiaries can change the trust properties irrespective of the lapse of time. Secondly, people are, the trustee, a mischievous trustee, makes himself liable to criminal breach of trust. And if you really look at, until Nirbhaya, just to have a feel of what it means, what criminal breach of trust means, until Nirbhaya, the punishment given for criminal breach of trust was same as rape. It was 10 years of rigorous imprisonment. So the office of trusteeship, as I said, is an office of high responsibility, and you really need to have strong and broad shoulders if you are a person of integrity to do justice as a trustee. Now, when you draft, and these people miss out on this aspect, when you draft when you draft your deed of settlement, you have to make sure, you have to also lay down a code of succession. Eventually, you will die, and most people form private trust when they are of advanced age. Your friends who are co-trustees or your family members of that branch of family will most probably die along with you. How do you appoint new trustees, and who should be the new trustees? And remember, the property will vest in this new trustees. So appointment of new trustee, one is entire code for management. So first and foremost, make your objects very clear and make sure that cannot be construed to be as a public trust by identifying the class of people who will benefit. If it's a religious purpose, you mention it, it's only for the family. Secondly, you mention choose people of high integrity as your trustees. Give them ample management power, but always have a system of check and balances, and have a code for future line of succession. When you're creating a line of succession, now there are also corporates who render these trusteeship services. When I'm not a big fan of corporates, I don't personally think that Mr. X or Mr. Y can, or XYZ Limited is safer to deal with X and YZ Limited, which is a corporate giving trusteeship services, than your own people, than your own grandchildren. After all, why would corporates are corporates? They are, as I said, they're not natural persons. They don't have a heart. So, but when you sit down to draft your trustee, please create create a code for appointment of new trustees. And another thing that we should remember in mind, that a trustee cannot delegate his responsibilities, but he can employ people. So put that in your code. See, a deed of settlement, you're actually you're settling the property, and you have to think of making an organizational code. Now, it is all of us know that a trustee cannot delegate his responsibilities. He cannot assign his office. Similarly, beneficiaries too can't assign their rights, especially where the household concern. See, even the natural, if I were a co-owner of a property, I cannot sell especially where the property concern is a dwelling house. Under transfer of property, I can't sell the dwelling house to a stranger. The others have a preemption right, and the stranger cannot foist himself in a family dwelling. He has to pursue a separate remedy altogether. So I have a very interesting case. One of our friends, he has his family has an old age home in Coimbatore, and I just once asked him whether once I grow old, can I come and avail of that old age home? And his first response was, it's not a public trust, it's a family trust, and for generations, the elderly in his family have been staying there and staying there rather happily. So these are some of the aspects of trust. Drafting, as I said, all of us look at precedents and we stop there. But we need to think through when we draft a trust deed. I have already touched upon what happens once the trustee has accepted his office. He cannot recuse himself. I've mentioned about corporates acting as trustees, and as I said, the efficacy of any trust depends upon the trustees. So I have requested Bapu to share with everybody, with the audience, his experience with a very interesting matter where a trust was created under a will.
Good evening, everybody. There is a saying that never take the stage after the start, because it's always a difficult act to follow. I've been hearing Divya say quite a few things about private trusts, and she's not left much for me to add, except maybe, as she rightly said, personal experiences. First of all, a private trust and a public trust, how are they different? A private trust is not really a trust. You might call it that, but it's not really a trust. It's an association of persons. A few people get together and decide what they want to do, or a few or many other people whom they specify. Or think of it as a club or some sort of sports association, maybe association of advocates, whatever it is. You have a very limited membership. It is specified who the members will be, and you have a set of rules and regulations, normally called a memorandum, which tells you how, why, when, where, whatever it is, to run that trust. It's very similar. There was a family, a father, mother, and a son. The father had a nephew whom he could trust very much. But the father wanted to make sure that his wife and child were looked after very well from whatever he left behind. There were a few complications. I mean, there are always complications in all everything. But here there were a few complications in the sense that the lady, the wife, who was also the executrix, one of the executrix, was not really 10% stable. I'm a bit surprised that she was made an executrix because under normal conditions, that should not have been done. But for whatever reason, the husband had made his wife the executrix along with another friend of his. The son was highly diabetic and no one knew how long he would survive. Now see the mother, not very capable, the son, extremely sick, and there is this corpus. What happens to it? Now, a lot of people, in fact, we suggested, and I would definitely suggest it, if you're going to form a trust, please do it while you're alive, survivors. Don't wait for somebody else to do it and put it in your will, etc., etc. It, it's a nuisance and you really do not know how to go about it. As with all trusts, the will of the settler is paramount. The objects of the trust are specific and have to follow come what may. Hell or high water, they have to be followed. Now, in this particular case, the will was drawn out and it was written in the will that a trust has to be formed. Now, the gentleman could have formed the trust in his lifetime and said that this is the trust. I'm going to I'm going to be the main trustee. There's no need to have more than one trustee. He could have been so trustee and said that after me, so and so takes over as the trust. But anyway, somebody must have advised him in a different way. We don't know why it was so, but that is what that those are the papers that came to us. When the papers came to us, the son had expired, and the second trustee, along with the wife, had sold off some property where the woman was staying and given her some flat far away from Bombay. It was in the building that actually the lady owned. I don't know why she gave it up and where she went 400-500 kilometers away into a tier 2 or tier 3 city. Anyway, this is the position that it was when it came to us. And this is a rather common thing. People, when they make a will, forget a lot of things. I mean, even even if we are drafting a will, we could be accused of that. But here, a lot of liquid assets were mentioned only by name. In fact, when we started, we could only trace about 6 lakhs rupees worth of assets. And one day, in one house where they were staying, my client came across a piece of paper, an envelope. He opened it, and guess what? It was worth another 28 lakhs more. Some shares bought long time back, which must have been, I mean, they were, I know that they were absolutely blue chip. And now from 6, we have got 28 more. So we got 38 lakhs. What did the testator say? He said that my wife should be looked after for the rest of my life, her life. If my son survives her, all the assets are his to do what he wants. Very good. This is normal. Life interest for the wife and everything goes to the child. But here, the son predeceased the mother. So now we are left with a lady who has a life interest. She's the executrix along with some other person.
the other person recuses himself now when we come into the picture because he would be asking questions. So he suddenly recuses himself. That leaves only the lady. And mind you, as I said, she wasn't totally capable. And I don't even think she knew what to do. So technically, there is no executor. The main beneficiary is dead. There is a woman with a life interest who really doesn't know what to do. She's far away. She has never had any inkling of what investments her husband had made, except for the will. And in the will, it was very cursory. There is a good possibility that we might still come across something that has been missed out, maybe another 28, 50 lakhs almost. What did we do? How did we solve the problem? The first thing is we read the will over 10 times, kept on reading it one after the other, making notes. It wasn't a very big will, just maybe 8, 10 pages, or maybe even that, I forget. And we found that the only way that we could do it was naturally to go to court. Now, the lady, if she had gone to court, in fact, at that time, maybe that's another thing. Maybe the husband had made the lady the executrix because at that time they did not have to pay that 3 lakhs of rupees or whatever it is. A female did not have to pay that money for a probate. Later on, it was 75,000 for everybody. I think even now it's 75,000. But at that time, she had to pay nothing. So maybe to save 75,000 rupees, she might have made it. I don't know. But anyway, when we went into court, she was not there. And the nephew had to be brought on record. Now, you will see that if suppose that gentleman, the testator, had made a small trust when he was alive, made himself the sole trustee, operated the trust. When you make out a trust, you have to have the objects of the trust. Everything in the trust is objects, nothing else but objects. They have to be met. If he had written down that the object of this trust is to look after my wife, whatever income there is should be given to her, and after her demise, everything should be given to my son to do whatever he wants with it. And if necessary, after my demise, so and so will be the trustee. Unfortunately, nothing of the sort was done. In fact, bank accounts, name of the bank, but no branch, no number. So, quite a bit of money. We took 2 years to go to court. Never rush into court. Somebody says, Kal case Mado, ask him to come back after 6 months. You cannot rush into court. We took 2 years to make our case. My clients, the nephew, went to see the lady a couple of times, found out that all her dealings were through one local advocate. She really did not know what was happening. So we pieced all this together. And mind you, we still haven't been able to form the trust, which should have been done a long time back. Because in the will, it was written form a trust for my wife and for my son. There is no trust. One executor recused, the son dead, the lady incapable. It was almost a dead end. We worked for a couple of years getting everything into place. I mean, it wasn't a house of cards. It was a house which we built with a solid foundation. And very fortunately, which doesn't happen that regularly, but very fortunately, the clients did not argue on a single point. We would talk with him, explain things to him, discuss it, and then go ahead. He gave us the backing of a lifetime, which was excellent for me. Because unless your client is on the same page with you, it's always very difficult. In fact, this morning we had a lot of arguments when the client knew what he was talking about, but would not accept it. And as one judge said a couple of months back, both sides know the truth. It is the judge who is on trial. So when you have difficult clients, it is you who is on trial. Anyway, very, very decent client, very helpful. We went into court with all the papers, everything well laid out. And remember, when you go to court, please don't go to court to fight your opponent. Please go to court with papers to help the judge. It is not your client who is going to give the order, it's the judge.
So please make things very easy for the judge to understand. Give him choices, give him opinions, but let him decide in your favor by helping. And that is how all our cases, we don't fight, but all our cases are made out that way. We went into court, we came out 10 minutes later, in spite of that advocate in the Mofussil area suddenly turning up and asking me whether, anyway, asking me for what I could not give him. So I told him, you can have a cup of tea with me this evening. Tried to stop it. It did not work. We were fortunate in a couple of things. As I said, we've taken a long time, but we made a thorough case out of it. Very good foundation, very good structure on that. I myself very proud of that because everybody has said it's an impossibility, and we succeeded in 10 or 15 minutes. It's an emotional high. Another thing where we were very lucky was that we had a judge who was not only extremely, I mean, obviously all judges are honest, but all judges are not very courageous. This judge was extremely courageous. And when you go to court, it's called prayers. You pray to the court to give you something or the other. If you ask for the moon, you might get the moon. But if you don't ask for the moon, you'll get the. Here we had asked for the moon. We asked for direct probate, making my client an executor. Mind you, he was never named as an executor. Fortunately, we got that done. The client was made the executor and the probate was given, much to the annoyance of a lot of other advocates and counsel. But anyway, we got through. Now, the problem actually started. See, all this we have done. How do we form the trust? Because in the will, there was written that we must make a trust until either until the son is alive or the wife dies when we distribute everything to the son. Now the son is dead, the wife is alive, the mother is alive. So we've got to make a trust for her. Now what sort of a trust do we make? Remember, the objects of the trust have to be a trust, there would have been no problem. Somebody advised him not to do it and to make the trust after he died. The trust must be in consonance with the will. That means the objects of the trust must be drawn from the will. The beneficiary now is only one person, the mother. So the trust is made for the mother. How do we look after the mother now? The court naturally gave us instructions. So it was an agreement with the court that we would put all the money into certain securities, and whatever interest we received would be used for the benefit of the mother. Interest, not the capital, because the interest, actually at that time the poor woman was getting some 5,000-6,000 rupees. We've given them quite a bit after that, maybe some 20,000-30,000 rupees a month. The trust now says that there is this corpus, any benefit to the lady will come out of the interest of the corpus. We will give everything to her. No strings attached. We are not going to ask her what she's doing with the money, how she's spending it, whether somebody else is, whatever might be, it's not our business. The trust says, give the money, give the interest to her, we are giving it to her. The will also said that after the death of my wife, if my son predeceases my wife, that means the wife is left alone, everything must go to my nephew. Now the nephew is our client. He has been given the probate. He has been made the executor now. He has now to form a trust of which he is the trustee. So he formed the trust with the simple objective of using all the interest, that means the life interest, of whatever assets the old man has left behind. I don't know whether he was that old or not. I don't think so. Right, pretty, not very young, but just past middle age. So whatever we receive from the corpus is to be used for the benefit of his wife. Fortunately, after all these years, the lady is still alive. And the trust gets dissolved when the lady dies, because all the assets then go to the nephew, who is also a trust. Right now, the lady is alive. Right now, money is flowing to her. Let us see what happens later on. It was a very, very interesting case. Everybody said it's impossible, but God willing, as they say, the improbable we can do. The impossible takes a little bit longer. It took a couple of years, but this is how a private trust was formed. You can form a private trust overnight. There's not much to it. There's a couple of books also. There's a couple of books also which tell you how to form private trust. But try not to use the word trust in that, because now everything is computerized. And the moment you see a trust, the first thing is it registered with the Charity Commission? Now, this trust is an association of persons and it cannot be registered with the Charity Commission. If you go to the Charity Commission, throw it out. It has to be registered with the sub-register of assurances. So try not to use the word trust just because the computer picks it up and makes a nuisance of itself. A computer obviously cannot. I'm showing the book to you. It's quite a nice small book. In case you ever get the chance to buy it, please buy it and read it. It will take you maybe 4 or 5 hours to read. I'm showing it to you. Am I clear on this? Can you see it? I mean, I can see it as a mirror image, obviously. I will read it out. Private trusts, creation, uses, and taxation by C.A. Virendra K. Pamecha, Panecha. Because it's a book that's written by a chartered accountant, there's a lot of material on taxation. But the first few chapters will help you form a private trust. But please don't use the word trust. Use any other word, but don't. As I said, only because the computer won't pick it up and reject it. So be very careful. You might call it a trust, you might say that it is a trust, but don't put it in the title.
Do you recommend having one individual as trustee on a family trust? See, without a trustee, you cannot actually operate a trust. The settler can personally be a trustee and he can nominate another. He also gets an opportunity that way to groom the trustee. Which one is the better option, creating family trust through will or through trust deed? See, when a lawyer says it all depends on facts and circumstances of the case, it sounds so cliche. It depends. We had, in fact, client Bapu from Malcolm and Manka Advocates was advising a client, gentleman, a nice, wonderful gentleman. His major problem was if the property lapsed in the hands of he had 2 sons, both of them wastrels. Property lapsed in the hands of the sons. It's very, you make a guardian, you petition before the court and you can get the right to transfer the minor's property. You make out a case and it's usually granted. All you have to do is sometimes deposit the minor's interest into a bank account and say that when the minor becomes major, he can access those funds. But the concern of this gentleman was, he said, it's my life's earnings. I don't want it to go into the hands of my sons. They will just spend it all. But I want to vest this property in the hands of my grandchildren. According to me, in this case, a private trust in his lifetime would have been better. What do you think? Definitely. Although, see, the problem with our laws is that where immovable property is involved, especially the stamp duty, it's as good as a conveyance. So, although there may be certain stamp duty advantages in leaving a direction in your will, but
3 or 4%.
5%, 5 to 6.
Family.
Yes, it's as
anyway, even 5% is worth it. Otherwise, you lose in 5-6 points.
This is particularly true of and you get a feel when you interact with people who are of advanced age. What are their worries? What is the background they are living in? See, within your lifetime, once the trustee gets power, you'll come to know once a person has any type of power in his hands, believe me, it's bound to be misused. So you can also in your lifetime find out, sense how reliable your trustee is. Can a NRI be a trustee? Very nice question. Can a non-resident Indian be a trustee? Now, under the Public Trust Act, I don't think an NRI can be a trustee. But remember, a family trust is basically a private trust. It stands on a different footing. And I don't think there's any bar on an NRI being a trustee. See, what happens is,
One thing.
of a family trust.
a trustee should be close to the assets, especially on, it can't be very far away. So the trustee has to look up it.
Yes, that's a very important point Bapu made, that under law too, a trustee is bound to take care of the trust property. Now, if you choose an NRI, especially as far as movable properties are concerned, it will be difficult for him to administer his duties. And remember, accounts to foreign funds are not easily transferable, or collecting rents. But there is no, I don't think there's any bar for an NRI to be a trustee of a private trust. Public trust, yes.
Another thing, when there is no prohibition, it is prescription.
Okay, Divya, there's one question on the WhatsApp. Ma'am, you said that one should avoid appointing corporates as trustees, but there are so many banks rendering trustee services. Why do you say we should not appoint?
Well, it's largely based on my personal experience, personal experience dealing with corporates. I mean, after all, you're creating a family trust. And it also depends on the beneficiaries. Sometimes, in this particular instance, you're making grandchildren your beneficiaries. So I don't know. I don't have much faith in corporates. I mean, what do you say? Plus, that can be a very expensive proposition
Yes,
too.
they can charge you quite
They charge a substantial sum as their fee. Sometimes
minimum 1% of your asset value.
yes, it's based on the asset value. So it's an expensive proposition. When you appoint see, again, criminal breach of trust, you can catch hold of an individual and tell him 10 years in jail. Corporate, whom do you catch hold of?
Okay, the next question is, does the beneficiary have right to access the trust deed?
Yes, so under law, the trustee is supposed to keep all the original trustees with him. The original documents of title in his custody, because he's after all the custodian of the property. So the trustee is supposed to keep the original, and the trustees can ask for these documents. They can ask for accounts for sure.
Does the beneficiary have a right to access the copy?
He can have an access, but the original should be in the custody of the trustees. The trustees have.
The trustee is no more than a manager.
Yes.
But the duties are far onerous than an ordinary manager. He works for the benefit of the beneficiaries. So it is his duty to keep them informed of how the trust is running, if and when they ask. But if and when they ask, in that case, a trustee has to inform. I mean, in a public trust, he has to file papers with the charity commission. They come, now they're available on the net. But a trustee is a manager, and just like a good manager, he has to make sure that there is no hanky-panky. And the only way you can stop hanky-panky is by being transparent.
Okay, so as a practice, do trustees work without consideration, or most of them do take, even if it's a family member?
Both. You can give it a trustee some amount, but not 90% of the trust assets. Or you can give the trust, and normally what you give the trustee is expenses. I mean, if getting accounts audited, you give the auditor, paying something to the bank, maybe servants to look after the property. If it is a farm, you might have to grow crops and sell them. If it is a building, you might have to maintain it. All this will come out of the trust funds.
So one thing we need to bear in mind, that typically in a family trust, the trustees are also the beneficiaries. And that's why they have a vested interest in running a nice tight ship. In a family trust, you would obviously make, and invariably that is the case. The trustees are also the beneficiaries. Supposing you have a child with special need, you have another child who is perfect, and your wife. So when you draw up a deed of settlement, you and your wife would be the trustees. So it's not that you are doing the wife out of inheritance, she too will have a stake. So that's how it really functions in family trust. Invariably, the trustee is also the beneficiary. Somebody has asked about the average cost of forming a trust. And as I said, it's a thumb rule. If it says immovable property, the stamp duty is the first cost that comes to my mind. Taxation perspective, really, I would not be the right person.
It depends on what the income is.
Comment on that. Yes, and what
it will be what the income is and how much you are spending. Normally, the ratio is that you can spend. If you don't spend 60% of the income,
That's
I
right.
told you that we are spending 10% of them,
Right.
giving to the un. Otherwise, you would have to pay some tax because in the public trust it is
So
60%.
private trusts, see, private trusts are usually, I think, governed on the basis, as Bapu rightly said in his presentation, as association of persons, but we would not be the right persons to comment on
This
how
book
much.
will tell you, that's what
For that, I think better to consult the chartered accountant taxation perspective. But yes, forming a trust involving immovable property is a cost. It's a heavy cost, at least 6%. Stamp duty is a cost. But there too, you might get some sort of rebate if you say it's for immediate family members. You'll have to look up. I had the stamp bag ready with me right now. And about running costs would depend upon what is the fee when people uh, put the immovable property in trust. Immovable property has, it's a capital asset. As a thumb rule, any capital asset you have to keep something like 5 to 6% aside for the maintenance of any capital asset, especially land. There will be taxes. If you have a servant, salaries, repairs, depending on if the building is aging, then the repairs will be a lot heavier. Insurance.
So, Divya, before we close, what are the advantages and disadvantages in a brief, if you could just tell the participants of the family trust?
So, as Bapu rightly said, compared to a will, you can revoke a will anytime without cost and without any hassles. Supposing today I decide to, bequest my property, or in the will itself, I say upon my demise, the executors will get together and put this particular property in trust for the benefit of my grandchildren. And tomorrow later I find out that my grandchildren too, I'm very disappointed with my grandchildren. I can revoke it anytime. It's a will. But once I establish a private trust, then revocation is you'll have to take everybody's consent, because then you see, once you form a private trust, the trust deed itself, the deed of settlement, yes, it becomes a code. Nobody can. So if that code has to be changed, you have to get everybody on the table on the same plane, everybody affected by that code on the same plane, on the table, get their consent, and then undo the effects of the deed of settlement. Unless, of course, in the deed of settlement itself, you have made a provision for revocation of the private trust, but then it defeats the aim of, if you make a reserve the power to revoke it, it defeats the, because if you look at our Maharashtra Stamp Act especially, it says at the time of payment of the stamp duty, at the time of formation, any clause regarding revocation should be ignored. So you go through all that pain, you pay all that money, and then you only, because you're not uncertain, you reserve a right for revocation. And with this disadvantage is also the advantage. You get it? So once it's done, it's a fair company. Nobody can undo it. So so that is one of the biggest points I would like to make as far as the trust is concerned. Of course, it's perhaps the only way of parents with a special child with special needs can ensure that the child is looked after once they die. If we talk to parents with a child of special needs, I mean they are really afraid what will happen to my child if I die tomorrow. Sometimes they wish that the child passes away during their lifetime, and as they age, as they are in their 60s and they are in the 70s, it's a big worry. Their major worry is what will happen to my child with special care. That's where private trust can help in a huge way, in a big way, because you form the trust in your lifetime, you appoint trustees, and you make sure at least your child with special needs is looked after.
Yes.
Thankfully for it's always entertaining for us to be on PLEA's platform, and wonderful opportunity to connect with students and fraternity.